Oh my gosh, it's finally here. Closing arguments. I can't believe it after 21 days. Good morning, everybody. I've got so much. I came in a little late today because I have so much to say. I've been thinking about it all morning to the point where I forgot to put my makeup and put my contacts in and all that. It was like 5 minutes. I'm like, oh my God, I got to do this. So I'm so excited. Good morning, Smiley in New England. Good morning, Greens Garden. Good morning, Judy. I know you're in here as well. So what can we expect today? I think we played Good Morning, Judy. I knew you were in there. Good morning, Lisa Fortunato. It's good to see everybody. We've got a poll up as how long you think it'll take the jury to deliberate. So you'll definitely check that poll out. And I'm going to talk a little bit about what we can expect. Of course, I didn't have any water this morning. I probably didn't have any water most of the day. My kids say, Mom, you need to drink water. But anyway, I'll get through it. So the defense goes first. Defense attorney Reddington, in my opinion, and we listened. Some of you guys might have stayed on yesterday, but we listened to Resnick again, who is the top witness for the defense. And I've actually recorded a clip that we can even play later of Resnick. So here's what I think must go on. Reddington must directly confront the prosecution's digital. First of all, he's got to bang on Dr. Resnick. That's his most qualified and most renowned expert, and say how renowned he is. But before we get to the expert, I think Reddington must, confront the prosecution's digital evidence regarding her Google searches and the GPS tracking. He must argue that a person suffering from active psychosis can still perform routine functional tasks like ordering food or checking transit times, driving a car, building a snowman. So basically, according to Dr. Resnick, I remember the testimony yesterday when we re-listened to it, she can be somebody who's functioning, but still psychotic. And she can wax and wane. So you can go in and out of it. And if I were him, I'd quote right from Dr. Resnick about, yes, she can, just explain that waxing and waning. So yeah, she can actually do these things and then be in full-blown psychosis. And that's what we saw here. So then he must obviously, again, hammer Resnick, that the core testimony there was Clancy was under an overwhelming altruistic delusion. She was under the influence of a powerful command hallucination, that she genuinely believed her children were in imminent danger and would be safer in heaven with her. And in her mind, she wasn't committing a malicious M. She was performing an act of distorted psychotic love. So he's got to hammer that home. And he must forcefully remind the jury of the sheer volume of, and of course he will, he did this in his opening, of heavy psychotropic medications that she was on leading up to January 4th, 2023. So again, you're blaming the medical community. You're making those jurors think about all those different pills and all the different reactions which it could also ultimately have a negative effect upon her. I think he must also counter the prosecution's fractional pill consumption. Remember that, there were still pills left in the bottle, by arguing that the rapid starting and stopping and the overlapping of all the different drugs, like the Seroquel, the Zoloft, the Ativan, et cetera, Lamictal, all that stuff, he'll have to explain that created an unpredictable, toxic and volatile chemical environment in her brain that completely shattered her cognitive control and volitional capacity. So he'll hammer in on the medications. I also think that the defense will aggressively contrast the timing of the psychiatric evaluations. This is a big one. He's gonna poo-poo all the Commonwealth experts here. So he's going to say, well, the renowned, wonderful God, Dr. Philip Resnick, the nation's most foremost legal authority on maternal filicide. He wrote all these articles, evaluated Clancy a mere 4 months after the tragedy. So again, ringing the bell for Dr. Resnick. He also must paint the state's rebuttal experts, such as Dr. Mack, Sathoff, as they're just clinical hires who conducted highly, detached hindsight analysis years after the fact, literally years after the fact. And they completely missed the active raw postpartum psychosis window. And in fact, what do they really know about postpartum anyway? Blah, blah, blah. So the most powerful, and I think also he must hone in on a very powerful tool. I wouldn't be surprised if he did this at the end. We'll see. I think he must focus on Patrick Clancy, the father of the children. And that's where the sympathy can come in. And he must remind the jury that the primary victim of this tragedy testified to his wife's, Lindsay's, deep, unconditional love for her children and her desperate cries for medical help. The defense must close by telling the jury that if the father of these children recognizes that this was the result of a devastating maternal mental health emergency, what loving mother would do this to her children? It's not a cold-blooded crime. The state has no right to demand malice or a life sentence in prison. So basically, you can say all of the witnesses described her as a loving mother. What loving mother would do this to her children? She had to be in a psychotic break. That's my thought. Okay, that's Reddington. I need some water so desperately. Can somebody email me a glass of water? The prosecution's core strategy here, I would say, obviously, focus on those beautiful 3 young child victims, and they will do that. Remind jurors of, show them pictures of the beautiful children before, and then talk about, so obviously focus on the victim, and then, go into, obviously, you got to be careful what you're doing, but somehow remind jurors of those, the ligatures, the autopsy photographs in somehow a subtle way. They have to bring that up because it brings it home. But these child victims, you guys are all talking about it in the chat, so they have to bring that home. Justice for these 3 children. So they have to show that they are the voice of justice. They also will get into, they have to show that Lindsay Clancy possessed full cognitive capacity, intent, and control during the specific, whatever it was, 40 to 50-minute window where she was alone with the children, right? Rather than portraying her as a perfectly healthy person. So I think the prosecutors will focus on demonstrating that, she did concede that, she had depression and anxiety, but what she had did not cross the legal threshold into a mental disease. Well, she does have a mental disease or defect. Okay, that's both sides. Have agreed to that. I mean, they haven't stipulated, but both experts agree that she had a mental disease or defect. But that they have to argue that this mental disease or defect actually did not rise to the level of a psychotic break. She still knew what she was doing. And I would stress Sathoff. Some of what Sathoff said, we heard yesterday, argued that these crimes were not the result of a sudden chaotic psychotic break, emphasized that Lindsay meticulously created that window of time, isolating by tracking her husband's movements, sending him on a precise sequential errands, and used that forensic testimony that Whiffen testified to. So, look at the digital forensics here. They'll use the Apple Health data and the GPS tracking to show a highly organized, logical mind that was actively calculating these transit times and executing a deliberate plan to take those children and then herself. And they need to remind the jury that the exercise bands used in the killings, this type of manual strangulation requires sustained physical effort over several continuous minutes per child, and repeat some of what Sathoff said. The commanding voice didn't tell her how to do it, when to do it. So there had to be some sort of cognitive planning. Oh, I'll bring them down to the basement. I'll use the exercise bands. She talk about maybe crushing up those pills. Is that what she thought of doing? And then it was too hard. So there does seem to be quite a bit of thinking involved here. And there was evidence that during the day she was rational. She presented, she could talk normally. She spoke to various witnesses. So focus on how she was rational throughout the day. Stress that she had to repeat each act 3 separate times. It took time. And what did she say during the act? Go to God, baby, go to God. I think they will argue that stopping and moving from one child to the next requires some sort of renewed conscious choice to continue, which defeats the defense's narrative of an uncontrollable dream state. So that makes sense. They'll have to really be clear and articulate. I'm not sure if these prosecutors can pull it off, but we'll see. The Commonwealth will also reuse their physical evidence, the pill bottles, to dismantle the defense's involuntary over-medication claim. They'll have to remind the jury that the pills counts prove that Clancy was only consuming a small fraction of her prescribed doses of trazodone, Ativan, buspirone, and they have to argue that this was a fully functional, clear-minded individual steering her own actions. I can't talk today. I really need that water. So the prosecution also will heavily leverage, I'd say, they need to stress their experts. Dr. Avram Mack, his qualifications weren't great, but they'll have to, stress that the strengths. And Helbrin, I think Heilbrin and Sathoff were the best. I would have just used those two. They'll argue that this was a methodically highly unusual and convenient, that Lindsay seems to have heard a command voice only during the exact 18 minutes of the killing. So they've got to stress some of what their experts said, because it made us think about it. And they need to hammer home her telling the children, go to God, baby, go to God. They'll argue that this specific phrase, combined with her immediate, S attempt, proves she possessed clear moral awareness and fully understood that these actions were wrongful and illegal under Massachusetts law. So that's, I think, what they need to do. And, I'm thinking if I'm the prosecution, you'd start with something like, this trial is not about whether Lindsay Clancy was struggling or depressed. It's about cognitive capacity and control during a critical 40-minute window. The Commonwealth, has proven that this was not a sudden, chaotic, psychotic break. Her mind was highly organized. She meticulously engineered a window of time to be alone. She tracked her husband's precise movements via GPS, and she made a conscious, deliberate choice to take the lives of her 3 innocent children. And the hard, cold forensic evidence proves that she possessed full moral awareness and knew exactly what she was doing. She knew it was wrongful, and she knew it was criminal. So that's kind of how I would start if I were the prosecution. So that's my 2 cents. I guess it was a lot more than 2 cents. I need to get a quick glass of water. I will be 2 seconds, I swear. But I really do need a quick glass of water. Okay, I'm back. All right. So I couldn't get a big tumbler because let's say the water where I live is so bad. It really is. It shouldn't be, because I pay a water bill and I have to put it through a filter, and the filter needs to be changed so it only comes out slowly. So this is all I could do, but it's good enough. Okay, so let's talk. I'm very excited about these closing arguments. And again, if I obviously I was just trying to go through it in my mind, and if I missed something, let me know. So, Lisa, I'm going to start with you. Good morning. Good morning. Lisa says, I'm having a very hard time with it. I just can't get past that. And I just feel that the jury is going to feel the same as the way she did it to them, K'd them, what she used. Yeah, I agree with you. I agree. And that's what the prosecution has to really hammer home. They really need to be organized and forceful, and they can't waffle. They go last in Massachusetts. Not all states do the same order. It's kind of weird, really. But in Massachusetts, they have the last say, and they have to come out, like I said before, they have to come out swinging. And I'm not that impressed with these prosecutors throughout the trial. Mutts, honestly. So I wonder if it was, and I hate to criticize other lawyers in my own field, but I'm not that impressed, to be honest. I'm really not. All right, so let's see. Yeah, that's okay. Unalive, that's all right. Yes, it is heartbreaking and unimaginable. I can't fully let my mind go there. Yeah, I hear you. What about anybody? So don't be afraid to speak up. This is the no judgment zone. This is why I created this particular channel. I feel that now that I'm older and wiser, see, I'm not one of these young TikTokers. I feel that, this is a place where we can freely offer our opinions. So anybody, don't be afraid to offer your opinion if you're on the other side. So we have a lot of pro prosecution here, but please give some thoughts on the defense case, because I think they were pretty good. I think Reddington is, again, what Reddington needs to do is really stress reasonable doubt. Stress that, he could, because that's his job. The Commonwealth has the burden of proof that she was sane. So place as much reasonable doubt, use those terms, reasonable doubt. So when the jury deliberates and they're thinking, well, we don't know who to believe. There's a tie. This expert said this, but we kind of thought this, it's interesting, this expert here, if they're like this, or it's 50-50, 60-40, that should go to the prosecution. I mean, to the defense, reasonable doubt. Okay, Judy, she's a kid compared to him. When Reddington was calling her a kid. Yeah. That's just Reddington being old, right? That's the way he talks, I think. So, and I think the jury will understand that at this point. They know he's older, and they know he's he's been around the block for a long time. You can tell right away. Wonder why the DA sent those two assistants instead of him. So the district attorneys themselves never try cases. Like, at least I haven't seen it in Massachusetts. They're like big figureheads. They probably, they're usually lawyers who have tried these big cases in the past, but they're a figurehead and they're elected here in Massachusetts. So it's almost a political position. They do have a first assistant DA, and sometimes the first assistant DA will be the one that gets the big murder cases. I'm not really sure why they assigned these two. Maybe they wanted women because it's a postpartum depression. It's women's issues. But I'm not that impressed. And I'm surprised because I was an assistant DA in Massachusetts, and I felt that the assistant DAs are pretty good here. I really do. I mean, by the time you get up to doing the M cases, I think, you're experienced and you're pretty good. But these guys just seem not as put together, right? I don't know. I'm not that impressed. Okay. Because they are females. That's what I kind of thought as well. I imagine they wanted to choose females here. So I don't know. I think we're on the same page there. But usually there's really good females as well. So there's good male and females. All right. Pink Door. Good morning. That being said, I have found Reddington horrible, and I don't care of his age. Unacceptable to call the lawyer by your first name. Sexism. Okay. Sexism. That's really interesting. So many of you have also thought that he comes across as a bully, and this is interesting. You think he's sexist. Jurors are thinking along your lines. I know there's at least one juror who picked that up on that, Pink Door. I think you've definitely got, you're onto something there. They might not like that. They might not like the fact that he called her this kid. And and calling the DA by the first name. Yeah, I hear you there. So let's see. Smiley. Good morning, Smiley. Smiling away. I believe it was premeditated. She planned it, knew that what she was doing and that it was wrong, and planned her defense early on, if not before. Writing, do I need an attorney? First thing she said. Yeah, that's another thing. You're right. For some reason, there's so much evidence that I forgot that she said that. She absolutely said that. What about somebody for the other side? We need somebody for the other side. I'm not impressed with this prosecution. Good morning. Phyllis, I went to the grocery store yesterday deliberately thinking of you and looking for sunflowers, but they didn't have any good sunflowers, so I was bummed out and I couldn't get them. But maybe today. But I was thinking of you with this sunflower. And I get it. I agree with you. So Lisa Fortunato, Michelle, I saw that too. That's why I was saying that I saw a documentary, and when he talks about psychosis 25 years ago, when he was speaking about Andrea Yates, it doesn't fit Lindsay Clancy. Okay. So this is interesting. Michelle Reddington keeps bringing up postpartum depression and postpartum psychosis when she was never diagnosed with it. So prior to, she was never diagnosed with postpartum. Well, I think some of the medical, I believe Tufts or they were looking at the postpartum depression part. I think everybody agrees she did have some postpartum depression. Um, postpartum psychosis, none of her medical records reflect that she was diagnosed with that. Of course, Resnick is saying that she had postpartum psychosis, and he did explain that. I think there was another battle of the experts about postpartum. Can it occur like 8 months after giving birth? Resnick says, yeah, it's not frequent, but yes, it can happen. And some of the other experts were saying, I don't see this as postpartum because it's so much after the birth. But I thought Resnick was more believable on that point, believe it or not, because I know, just being a woman and knowing our hormones, and I wouldn't be surprised if it was a postpartum event that occurred. So I do agree with Resnick there. This is interesting. Pink Door. Even after Resnick, when you really listen, he says, in this sense, it's postpartum psychosis. But even he did not diagnose that. Yeah. We went back and we listened to Resnick yesterday, but he did say she was psychotic, in his opinion, that she was in a psychosis at the time. And I actually recorded it. I don't know when the jury's going to come out, but I was going to play that for you. Good morning, Barb. I know you're in there because I see people say Barb, at Barb. Yes. So you must be in there somewhere. I missed what you had to say. It's really interesting. I'm reading. All right. You know what? We'll have to listen. I did record it right before this, but then I didn't put it up into StreamYard, but I have it. We can look at that. Let's look at that after closing arguments. And you know what I want to do this week? What I was trying to do was take snippets from Resnick and then snippets from Heilbrunn and some of the others, and we could put them together, like just like, instead of not with all the blah blah blah, but really the key reasons why they came up with what they came up with, or make a chart. So I've got to do that, because I think that's what the jury is going to have to do. It's really boils down to a battle of the experts. Oh, and by the way, there was some confusion in the chat yesterday. I didn't see it because I think I was blind, talking about something. But after the charge, so the charge, there was some confusion about the charge. Yes, the judge is absolutely going to charge this jury on first degree M. So all of the elements of first degree M. And it appears to me that he will also charge the jury on manslaughter. So they will. So that's a lesser included of M that the jury can consider, and that manslaughter carries up to 20 years in prison in Massachusetts. That's up to, and then murder, obviously is life without parole. So that's going to be part of the charge. I believe it, and we're not going to have any instructions on instructions on police misconduct or investigation. He's not going to do that. Let's see. I mean, it's pretty much the standard jury instruction. So that's really interesting. Lisa, you think it's going to come down to manslaughter? It could. We'll see. Now, here we go. I'm so excited for these closings.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
Well, good morning, everyone. Good morning, counsel. Good morning, Ms. Clancy. All right. The party's ready for the jury?
Yes.
All right. Please.
Court, all rise. Jurors entering.
All persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth within the full of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
Thank you, Madam Clerk. Well, good morning, everyone. All right. Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? Right. Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right. Again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charge as my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it is I kind of split it up. So I'm going to give you First half of my instructions will talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right.
That's funny.
So they take a while. All right. And they can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend.
Good morning.
Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right. So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right. Now, so my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all of my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you.
Just like me.
Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If the defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment, as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callen Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callen Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callen Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and or Callen Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and or Callen Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callen Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callen Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and or Callen Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and or Callen Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callen Clancy. A defendant's act is the cause of death, where the act is a natural and continuous sequence, results in death, without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of 3 ways. These are that the defendant, A, intended to kill Cora, Dawson, and or Callen Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and or Callen Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those 3 ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and or Callen Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callen Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and or Callen Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and or Callen Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right. And I discussed those elements earlier when I discussed the charge or the theory of first degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right. Now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first degree or second degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora, Dawson, and/or Callen Clancy. 2, that the defendant intended the conduct that caused the death of Cora, Dawson, and/or Callen Clancy. And 3, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callen Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates, a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right. And I'll go over that a little bit later, but I just wanted to remind you that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right. And so, counsel?
I'm going to switch the feed for a second. One second, because I think this is better. There we go. And let me get to it.
About 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. And all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country which country you are as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callen. She knows loss. And that's why we think of Cora, Dawson, Callen. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell the jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something. As I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living real life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, the screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window, sliding down the house, and Lindsay screwed up. And she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat. Googling suicide. Googling drugs. Googling side effects. Googling ketamine treatments. Googling all of these drugs. Googling the effects of Tufts medications. Lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, myrtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in her house with her husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. Put that over in the bad pile. Right here. We spent all that time showing through Dr. Laposada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you ever played pool. I challenge you to tell this jury why we spent a week showing that she committed, your witnesses.
Counsel, address the jury, please.
Said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Laposada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Laposada and says, wrapped. They were just wrapped. They weren't knotted because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Laposada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children to the point where he had to struggle. And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest, he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective. And it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away because, as Dr. Laposada said, you're talking about 4 or 5 seconds so somebody passes out. No, they got to have the 4 minutes. And that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement. Her throat was crushed. You heard the 911 team. You draw the inference, whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. you determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges are before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? Do you even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Did they do lousy investigation of this? Well, that's okay because she was guilty, and they put her in the hospital, and she's the evil woman who killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift. I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers? Remember Meg Collins? She came in this court. Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you've heard evidence, comes out of surgery, they're delusional. You've had anesthesia. You've had think about having your tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there, paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the what is it, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You heard the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no. They were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine. One of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolada gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it. And we held it for 3.5 years. Anybody care about it? No. You had evidence that the police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth, worrying about the child with the, I forget, where they rub the thing like. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking. You've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know, beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2, Mac, put him aside. You've got the other doctor as well. So Mac is, why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her, one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halbrun. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. Huh? She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. You're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of a humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Tewksbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. She's a good kid. She's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her. And God forbid they actually sometimes had dinner. Remember that? They got the Tewksbury records. Boy, there's a good score. Let's go through the Tewksbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly for 3.5 years. She's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. The guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet she was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records. She signs the HIPAA forms. They don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zeisel had in his report. They know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate. And more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Callen. And they were paid for their testimony. We're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them. Everyone says they looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, times 3. Has any of the government doctors rebutted that? One of them, Halburn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday who didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed. And I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why? The how? And the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect. As Dr. Zeisel said, that she was suffering from a disease or defect. As Dr. Condi said, she was suffering from a disease or defect. And Condi took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence. So you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday. She lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard, charging, manipulating woman that was controlling and everything in their life was controlled. And she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callen, put down for a nap. Hopefully we'll nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible, intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I don't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs. And like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote, to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time she killed her children. You all remember this. October. This is not an evidence, it's marker identification. It's too big. So, but basically it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? That's manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callen, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you ever watched the movie there, The Shining, with Jack Nicholson. Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice one. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you got when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right? You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the baby, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You think that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live her life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was, along with the fact it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, remember, there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head, and it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, Como.
I thought that was very good, by the way. I just have to say. I know you don't agree with me, but I thought it was good. He's so passionate. He really believes in his case. That's what's coming across to me.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether, at the time she killed Cora, Dawson, and Callen, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The two older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callen 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for 125 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you 2 options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medications she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do is she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking, because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work and that it takes time for them to get into your system and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted it faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to MGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts. You need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never says she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she's just, no, doesn't want to do them, and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, but she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore. Didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought. That telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought. Because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad. It's because it's wrong. It's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then we get to her being admitted to McLean. You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them have been out of her system for months. Zoloft, she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Cora's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. She shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science, you have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Codder as well. Similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report. And they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom, obviously, was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How does Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now her mom wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day, very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis, all the way up to January 23rd. Nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. When this is on her phone, you can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Maps search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have kids Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it and then go on to 3V so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced. And then after that, she texts Patrick, you know, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialyte and she knew about 3V and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialyte? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And you know that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense and life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS. Even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34. And then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, what did you do? And her response is, I tried to kill myself. And then it's, where are the kids? In the basement. It's not, I heard a voice. I was compelled to do this. I didn't want to do this. Go help the kids. They're hurt. They're in the basement. Go save them. No. It's, I tried to kill myself. And the kids are in the basement. And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised. Her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records. You know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time, and then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time, and then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report. You can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they had, to telling him to get it, to making sure it's on stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted, so I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots. And he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson. And he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted. They weren't tied. They don't just stay there on their own. And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m., because he's making the call to her at 6:09. There was not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20 odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have moved down to her mother's. She could have killed herself and left her kids alive, but it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted. And when she woke in the hospital and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children.
Counsel,
said that was all accurate.
Let's move on from that.
Lindsay Clancy hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance. You have to kill the kids so you can kill yourself. And then she tells the chaplain, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these 3 different versions. Another red flag, it doesn't make sense that she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice and you have no free will whatsoever, you're just your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself. That's acting on compulsion. That's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Satov talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse, those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. She landed the wrong way and ended up paralyzed on the frozen ground. But, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to. She was trying in all these different ways. But she just couldn't get over that third prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callen and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callen never got the chance to dream. Who knows what future he would have dreamed for himself? She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty, she is guilty.
All right, thank you, counsel. Now, members of the jury, been sitting here for a while. Does anybody need a short break? I think that would. All right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there.
That was powerful. Jeez.
All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but specifically for the charge in murder in the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right, so I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless your guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. The charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial is conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions and anything that I've said during the trial, not evidence. All right, so if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when no witness, Circumstantial evidence is when no witness can testify directly about the fact that sought to be proved, but you are presented with evidence of other facts, then asked to draw reasonable inferences from them about the fact that sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses, all right? It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says or only part of it or none of it at all. If you do not believe a witness's testimony that something happened, of course, your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field, does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? So I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that, all right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right. So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay. Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling this, I'm not suggesting you'll have one, but if you should do the following. All right. You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it. And then I'll either bring it back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing, send me a note and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone. All right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating. All right. So no subcommittees in a sense. What you do as a group. All right. You do it all together. Now I'm going to get to a difficult part, reducing and sending out the jury. All right. When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12. All right. And so the way it's done is the clerk will draw the alternates' names. We put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so and it happens fairly regularly. They would have to substitute one of the alternate jurors into the deliberating jurors, because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. As I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations. And it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point?
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14.
What I kind of forgotten to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callen Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. And there's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest respectfully that each approach it with a mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason, and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident you'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
All right, I've got a lot to say. So I just felt that both sides did such a good job here with closing arguments. And the jury has quite a task in front of them. But you hold on and you can hear all of my legal analysis on the case because, like I said, I've got a lot to say. And I expect this jury will be out for at least 3 to 6 days. They have to. And I'll tell you why they have to in a moment. So, hey, while we have all these people here, press the like button, please, and subscribe because I'm going to be continuing with my legal analysis on this case and other trials as they come up. Again, for some of you that don't know me, I'm Margaret McLean, former prosecutor and trial attorney, and I taught law at BC for a very long, 17 years, I think it was, something like that. So, well, I can go right into it because I'm not really sure. Oh, here's a poll. Okay, I like this poll. How long until we get a verdict? 5 hours or less, 15%. End of the day today, 8%. End of the day tomorrow, 31%. Monday, Tuesday of next week, 45%. I have to agree with the 45%. I think it's going to take a long time, and I'll explain why. I can start explaining why now, because in my opinion, this jury has stepped into what I would say is a legal, medical, and an emotional minefield. Look how divided we are in this chat. And anybody who is expecting a quick verdict, I think really hasn't been paying close attention. So, I think one of the main, let's just quickly look at the closing arguments. We witnessed two completely different versions here, really. It's like two completely different universes, in my opinion. So the prosecution argued that Lindsay Clancy, this was a calculated execution by Lindsay Clancy. They want the jury to look at the clock, look at the timeline, see the narrow window when Patrick left the house, and convict this woman who knew exactly what she was doing. The defense, on the flip side, on the other hand, described a medical horror story. Reddington was so impassioned. He wants the jury to look at a mother who was completely hijacked by severe postpartum psychosis and a toxic cocktail of prescription drugs. A loving mother who was stripped of her free will. Those are two completely different versions of events, and it's up to the jury to decide now. And I think to do it justice, they have so much evidence to sift through here. They must do it because you have 3 young victims. It's all about justice for those beautiful children. It's a very sad case. So jurors will look at those. They'll look at the photographs of these beautiful children, what they look like before. And then they're going to look at those autopsy photos. those gruesome autopsy photos. Then they're going to listen. I believe they will listen again to that horrific 911 call that I haven't personally heard. Most of if you were in the courtroom that day, you've heard it. But from people I know who were in the courtroom say that it was just horrific, hard to listen to. You hear Patrick in agony as he finds each child with those exercise bands. And he has to take them off. So it's just excruciating to listen to. They'll take that into consideration. Then they'll review the massive medical records from Lindsay's providers. They've got to go through those page by page because they need to do it.
Do each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed? That you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God. As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jurors, there be no votes. Construction, television.
Thank you, Pink Door. I really appreciate that. That makes me feel good. I worked hard. You know, we've all worked hard in this case. We've worked hard. You've worked hard just making comments in the commentary. I appreciate it very much. So I will continue with my analysis. My God, what a case. This is the most emotional case I have ever seen. And I thought the opening statements for both sides were good.
All right, everybody could be seated. I just wanted to make one comment. It really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing. It's intellectually challenging. It's physically exhausting. So I just wanted to commend all three counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
All right. Let me continue here. I was just making more notes. Oh, Barb, thank you so much. You guys are so sweet. You really, really are. I really appreciate you guys. And we're going to keep going. We are totally going to keep going with this. So as I was saying, this jury, yes, it's emotionally taxing. I think the judge got it right. And I agree. I just listening, I'm emotionally taxed right now. Think about, and I'll start over kind of, just think about the amount of evidence that they have to sift through. And again, I think the most emotionally taxing evidence is just looking at those three beautiful children.
In the hospital, and she knew she was alive.
All right, so we're going to take this down. Hold on. Let me take this down. Stop sharing. One second, let me stop her. All right, and that's just what happened was the feed that I had on continued, which makes sense. To stage, there we go. Whew. Wow. So as I was saying, they have so much. First of all, they've got to consider the three victims in this case. Not one single juror is going to be discounting those three victims. I'm sure they have children or grandchildren of their own, or some relatives of their own, little kids. It's just, they're going to be looking at that. And that's, I think they need to go through all of this evidence in order to do justice for those three victims. So that's going to what they'll start out with. Yeah, they're going to have to sift through look at the children's clothing with the blood on it, the blood spatters on it. They'll review testimony from all of the experts, right? All of Lindsay's providers. Listen to that 911 call. They'll review the testimony from the experts. They're going to have I'm sure they'll have a debate. What about Dr. Resnick? Do you believe Dr. Resnick? Do you believe Dr. Satoff? Do you believe? So they're going to be going through, I think they're going to have to make a chart. Prosecution experts, defense experts, and parse that out and figure out, who do we really believe? Do we believe that Lindsay was actually hearing voices? Let's talk about the voices. Well, she seemed rational that day. Does it make sense? They're going to bring their common sense and an opinion into this, just like we do on the chat, which, of course, they have such a big decision. Us on the chat, we're just giving our opinions, but they really have to decide guilt or innocence here. They'll have to look through the law, and they'll have to decide, after all of going through the evidence, who they believe, what witnesses to believe. They'll have to decide between first degree manslaughter, or a not guilty due to lack of criminal responsibility. So let's go through some of the highlights. I was taking notes during the closing arguments. And Reddington, was he ever compassionate? He starts out, this young lady did nothing wrong in her life. She's a darn good mother. You could tell he really, really believes in his case. He really believes in Lindsay Clancy. You could see it with every single bone in his body. He believes in his case. And he certainly called out the district attorney, Tim Cruz, and the prosecutors, claiming that the case is repulsive. It was repulsive and manipulating. The fact they even brought charges. He calls her a kid. So I'm just trying to read some of my own notes here. He claimed, I can't deliver it as well as he did. I actually thought it was effective because he was so passionate. He talks about, here's a woman in crisis. She was Googling all the drugs. Whoops. Oh, this is a press conference. Oh, thanks for putting that up. We'll watch this quickly. I've got Amber back there. All right, we got to watch the press conference. And then we'll get back to, all right, I can make that bigger. I do wish I was there, but if I'm there, I'm not giving you legal analysis. So that's why probably wouldn't have gotten in anyway. I would have had to get up at 3 in the morning, literally, to get in that courtroom. But I'm doing a better, my service is better doing this. All right, who's giving the press conference here? Well, in the meantime, I can still talk. So again, he was continuing to discredit the prosecution any way he can, like calling it a malicious prosecution, like he did in his opening statements. He talked about the bans, holding it for 4 minutes. Patrick, I thought he should have stayed away from the exercise bans as much as possible. I don't think he should have stressed it, because that's strong evidence for the prosecution. He said her throat was crushed. The idea that she could say, "Oh, the kids were in the basement," doesn't make any sense at all. That was Reddington talking about that. He attacks the police investigation. We knew that was coming. I loved how he used words like smoking gun. Oh yeah, he held that book up. Smoking gun. Oh, they found this piece of evidence. Good moms do bad things. Well, Gelada gave it to her. So he really tried his best to make the police and prosecutors look like idiots, in my opinion. Then he went as far as to say that Dr. Tufts, this was a good woman. She was a good person. Everyone loved her. But then it was Dr. Tufts who ruined her life and told her to take more pills And again, he called the DA repulsive, points into the audience at Tim Cruz, who's sitting there. Think how ugly that is. Blames the cops, calls them disgusting, what the cops are thinking about. Must have been Zeisel who came up with the idea to tell her that she's hearing voices. So he's really going all out here to try to make the Commonwealth look like they're the government. Oh, this big bad government who's out to get my poor client. Look what they do. They have no sympathy. They're trying to put her in jail for the rest of her life. It's horrible. He makes it out. This is the worst possible case I've ever seen, in so many words, right? And then he goes, and then he's talking about the Commonwealth experts didn't even see her for years. But Paul Zeisel, his expert, was right there. He's a friend of mine, but look at her. He was concerned for her. He's been with her for 3.5 years. He's a credible witness as an expert. And they call Sheila. He basically goes through some of the witnesses who called her, Lindsay, a beautiful soul. God forbid they have dinner. I'm just reading from snippets. He was talking about when she was in Tewksbury Hospital on the anniversary of her kid's death, and they talked about, she had dinner with her parents, and he's like, God forbid they have dinner together. God forbid. Like, this prosecution, the fact they even brought that up is sickening. Then, of course, he even says, I liked some of his lines, so I wrote them down quickly. He even said, Resnick is right out of a scary movie. Literally, I wrote down that quote. So that's his prime expert who's out of a scary movie. That's interesting. So then he goes on to say, Resnick has a world-renowned reputation, and their doctors agree. He's written the best articles on the voices. He's one of the leading experts in the world in this field on, the malingering or hearing voices, filicide. So he is way up here while their experts are way down here. So that's one of the main things that he says. And my expert, Resnick, evaluated her 4 months later. And I knew that he would mention that. And that is a big deal. And he says she was in a state of psychosis at the time of these deaths. So again, he's re-emphasizing what Dr. Resnick's opinion was. And I know that jurors will be talking about Dr. Resnick's opinion. And I think that, they'll do it methodically, and they'll probably go through the evidence and then go into the experts' opinions here. So then, of course, I love, he just cracks me up. I love how Reddington's like, Mac, he's just not qualified. If you even want to bother with Mac, it's up to you. Basically insinuating he's not qualified. And then with Dr. Sathoff, who we heard from yesterday, or Satoff, however you pronounce it, he'll say, yeah, the guy we heard from yesterday. So he doesn't even call them a doctor or a witness. He just like, yeah, the guy we heard from yesterday. Yeah, Mac said this. So he's doing that on purpose to try to show that the prosecution has a bunch of whacks. He's like, I wrote down these little phrases. It's a mess. Like, their case is a mess. Their doctors are a mess. What kind of expert testimony is this? It's a mess. She's not criminally responsible. The burden is on them, according to the guy yesterday. That was the tone of his cross. I mean, oops, so we're not doing the press conference, I guess. I didn't even know if I was looking at the camera. So, and then, of course, he's trying to convince jurors, this is Reddington, believe Zeisel, and then believe the guy that was with her for 3.5 years, the one that has been visiting her at the courthouse, and believe the psychopharmacologist who talked about the medications, talked about how she was losing control. And this was not just a hard-charging, manipulating woman who was controlling. He says witnesses testified to the opposite. So remember when I think it was last week, I went back and I re-listened to the opening statements by the prosecution. Reddington did too. And he did pull out some of those words, some of those lines from the prosecution, who really focused. This was a manipulating, controlling woman. But he pointed out they promised you that, but they didn't really follow through, because the witnesses testified, and this is true, that she wasn't controlling. We heard that from the nanny, Patrick, from her relatives, her father-in-law, and her coworkers, that she wasn't controlling. They said, in fact, yeah, she had schedules for the kids, but that was normal. All of them said that she loved her kids very much. So the fact I noticed that Reddington specifically brought that up, and I think he had to bring that up. And then he goes into the journal. Oh, the journal. There were horrible, intrusive thoughts. Her mind was gone. So he's trying to say that Lindsay knew that she was, she hears a woman suffering. She wants to get better. She's suffering from horrible, intrusive thoughts. Her mind is damaged. And then he's saying, well, these men come in here who don't even know. That's the experts. You're not a real person. He suggests that their experts are not qualified whatsoever. And again, he's not even naming them. And it's all manipulation. Again, he uses that word, all manipulation. That's what the Commonwealth is doing with their experts, even bringing these charges. She didn't want to go back to work because she loved her kids so much. And then he gets into Whiffen, and that, I will get to the prosecution's closing in a minute. I'm just going through my little highlights and my little notes. So he talks about Ian Whiffen, who is a prosecution expert. He noted that at the time, 5:38, what happens to the phone? CVS is on the way. And again, his job is to raise reasonable doubt. So he wants the jurors to think about some of the inconsistencies in some of the possible questions in the Commonwealth's case. That's his job. That's what he needs to do. So he's raising reasonable doubt about the Commonwealth's experts, about their evidence, about Whiffen. Anywhere he can poke holes and raise reasonable doubt, that's what he's doing. So I thought this was really interesting. Reddington, and I had a feeling this was coming, but Reddington suggested an alternative theory about why she made the Google search and why she sent Patrick out on the errands. And it was important for him to do this because Reddington said she wanted him home to help with the kids. So she checked the distances between the 3B restaurant and CVS because she wanted Pat to come home to help her. That is the defense theory. The defense says she loved her kids so much. There's no evidence that she's lying or malingering. That's exactly the mess this young lady was in. Those are his words. She had a damaged brain. And listen to Dr. Resnick. He'll tell you about the voices. That's what he's saying. Believe Dr. Resnick. She heard a commanding voice. Don't buy this, whatever word he wants to use, mess that we have from the prosecution, this manipulative mess. All right. So I thought overall that he was very impassioned. He believed in the case. And I think that he did come through the jurors. So I thought it was good. Yeah, some of you don't like his style, but in this case, I think he really came through and delivered a very impassioned closing argument. And he had to do that because you've got a case where you've got three beautiful, beautiful children who are no longer with us. And he did start out with being sympathetic for those children. So the Commonwealth, how did they do? I thought I liked Jennifer Sprague's. I liked her soft tone. It was a nice contrast after we heard Reddington's, impassioned, deep voice. I thought she was calm and collected, and that's really the style I think they needed to hear. And she calmly says, listen, the issue is whether Lindsay Clancy knew the difference between right and wrong. That's what's on trial here. What she did and what her mental state was at the time. She said that nice and calmly. And then she went on to say that Lindsay had more access to medical providers than a lot of people did. She had support from her family and her friends and her coworkers. She wasn't suffering from a lack of resources. She had depression, so they admit that. It wasn't the fault of the providers. She didn't take the meds as prescribed. So a lot of you in the chat have said this before, that yeah, she didn't follow up with her physicians. She didn't do what she was supposed to do. She should have stayed at McLean longer. All right, here's the press conference, and I'll be right back. Let's listen to false alarm. I love the fact that, Amber, you're in the background and you're watching the press conference so that we can have it live. Amber, I really appreciate you so much. I think you've been wonderful throughout this whole thing. What I would do without you, I don't know, because I was in New York City taking care of my beautiful twin grandchildren. I'm a grandmother, very new grandmother, by the way. So I had to go back and forth, and the Wi-Fi wasn't good where I was staying. So Amber, you've been wonderful, and I really appreciate you. I just wanted to say that. So, all right, they're still setting up. As soon as they start talking, I will be quiet. And we can keep this up, Amber, that's fine. As soon as we hear voices, I wish I could teleport myself and be there, but I think I belong right here for now. So back to Jennifer Sprague. As I said, she's saying she's not blaming the medical providers. She's blaming Lindsay. And she does it in a stern way, not a rah, 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 tough way. She is conversational with the jury almost, but in a stern way. And she says, so basically Jennifer Sprague blames Lindsay. She wanted help, but she wanted it her way. So early on, she's portraying Lindsay as a selfish person, if you read between the lines. She failed to tell her providers about the intrusive thoughts. We talked about this, the intrusive thoughts that she could harm her children. She told Patrick and she told her mother, but she should have told her providers. And we've all agreed with, I think most of our chat thinks along those lines as well. We wouldn't be here if she had told the providers. And, she was worried. The defense wants us to believe that she was worried her kids would be taken away. It's possible, but it's better than what ended up happening. I don't think the kids would have been taken away anyway. They have Patrick. They have a lot of support. She would have been taken away. She would have had a much longer stint at McLean, which would have been a good thing. Right now, I think they have her meds right. I do agree that it takes a while to get remember, my very close family friend suffers from bipolar 1. I've been in and out visiting her. We're very, very close. So I've been into McLean Hospital. I've seen her in psychosis, and it took years for them to get the right combination of meds for her. So it depends on each person. I think that's what the medical providers were trying to do. But you also have to be honest with the providers. Sometimes it's hard to be honest with the providers, but that's the theme that the prosecution is going for here. So I'm looking at my notes. So again, prosecutor says she's controlling her behavior. That's Lindsay. She's lying about her presentation to her medical providers. And I took that down word for word. Then the meds, they said it's not like she had this toxic combination of 13 different psychotropic meds all at once. Sometimes I think you listen to Reddington and you think she's, I wish I had a pill bottle here. I don't, but she's going ahead taking all these meds, and the doctors are telling her to take all these meds all at once. But the prosecution calmly says, no, that's really not the case. Look at the evidence. There were about two meds at a time. The medication trials were reasonable, according to the doctors. They just tried different combinations. And it's normal to have a trial and error process, according to the prosecution. Seroquel was completely out of her system by the time of the events, and I remember that testimony. Trazodone and Valium is what she was sent home with from McLean. Only those two medications. And again, she goes, there was no, I think this is what the jurors will debate as well. There were no signs of psychosis at all with her providers prior to the events. And I think jurors will debate that. That's another reason I think they're going to be out for a long time. They're going to debate what we debated. Well, how come there were no signs of psychosis? And then all of a sudden, in this, whatever it was, 18-minute window of time or whatever window you want to think it happened, she's suddenly hearing voices and she's in a complete psychosis. They're going to debate that. And then the prosecutor said, well, look at her also at the Museum of Science. She was irrational. You can see her. You can rewatch the video. The family they kind of blame the family, and I'm not sure what the jurors will think of that, but they'll say, look, the family never intervened. They never committed her. Lindsay was saying that she was getting better in the last text message to the mom. She's getting better, she's sleeping better, and she felt she was moving in the right direction. So maybe that's why the family didn't intervene. And then the prosecution went on to say, Dr. Tufts, for example, she denied hearing voices all the way up into the January 23rd appointment. That's the day before these acts were committed. So bottom line, Lindsay was not truthful with her providers. It's like, this is what the prosecution said. It's like she decided to be done trying. I'm done trying. I don't want to live anymore. And therefore, I'm going to do what I did. So that's their theory. Remember, as I mentioned in the very beginning, you have to have a theory to your case and you have to tie it all in through closing arguments. Also, then the prosecution Sprague goes to January 24th, arguing that Lindsay Clancy knew the difference between right and wrong. She was able to drive Cora to the pediatrician that morning, and that pediatrician didn't see any signs of postpartum depression or postpartum psychosis. She was able to play with the kids, and she was able to send messages back and forth on her phone and send photos. And according to the prosecution, by 4 p.m., the planning started with the takeout search, with the 3V restaurant search. And the prosecution said, she knew exactly where that restaurant was. So the prosecution said, if you're in distress, if she's really in distress, and so this was an interesting way of looking at it, Sprague says, it doesn't make sense. If you're in distress, don't send Patrick anywhere. Have him stay with you. Have him make sure you're okay. Have him drive you to the hospital. So she's saying that she knew exactly what she was doing. And therefore, when she made those searches, she knew how long specifically on that night, how long she needed to perform the acts, because according to the prosecution, she had already decided to unalive the kids and then herself. And then she added the errand to CVS because she's like, well, what if he calls me? I can't be interrupted. So I don't know what the jurors will do with that. And then Sprague pointed out, look, she spoke to the hostess at 3V restaurant. She called in the order. The hostess didn't notice anything weird or wrong with her, or her speech seemed normal. She was able to answer questions rationally. The same with the witness for CVS. She called CVS to see if they had the children's Miralax. So she sounded normal. So she brought up those two witnesses. And then when Patrick finally got home, he goes in the house. It's silent. He had to unlock the bedroom door. So it's interesting that she locked it. Then he unlocks it. He sees the blood. He sees the open window. He runs downstairs. And the first he sees Lindsay lying on the ground. He says, "What did you do?" And she said, "I tried to K myself." He asks, "Where are the kids?" "In the basement." Reddington wants you to think that she wasn't able to say in the basement, yet that's where Patrick went right to, the basement. So she must have said in the basement. He beelined it right to the basement. When he first gets there, the prosecution suggested that at that point she could talk. And then it got worse after that. That makes sense to me. And she did not mention anything to Patrick at the time about hearing the voice or I did something terrible. I killed, I K'd the kids, so we didn't hear any of that. And then she goes into the rationality of each act, and jurors will be debating this as well. So let's think about that. The prosecution said the act of bringing the kids to the basement, right? Each one. Then she performs the act individually, which I'll get to. Then she goes upstairs. She's able to take a phone call. She's able to get the knife out. She's able to attempt to cut herself. Then she goes out the window and she ends up on the ground. The prosecution said she's no longer bleeding. She must have started, they said she must have started doing this, committing the acts right away. As soon as Patrick left, because that was one of the arguments they made. And then she got into the whole thing with Dr. Satoff and Dawson eating the nuggets. So I'm sure the prosecution will talk about that. Patrick testified that he saw Dawson eating the nuggets and the green beans when he left. Prosecution says, listen, a puppet can't do these things. She's in control. She was able to answer the phone. She was able to climb 2 flights of stairs. She came up by 5:33. She took that phone call 5:33 to 5:38. She doesn't go up and down again because, according to the prosecution, she already committed the acts. And then she mentions Dr. LaPosada, talked about the neck. They talked Dr. LaPosada's testimony about the exercise bands. They stayed around the neck. So meaning like she was rational when she figured out how to specifically tie those bands around each neck. It took deliberation. It took some thinking. The voice didn't tell her how to do it. Patrick in the 911 call that she suggests they re-listen to it no matter how hard it is. He's not untying knots, but he's having to unwrap them specifically. So they're trying to make the argument that she's standing over their limp bodies until they went unconscious. And this again takes deliberation. It takes time to do that for each individual child. She unalived the kids as soon as he left. She didn't tell him. This is the prosecution talking. She didn't go down to help them. She presented pretty calm over the phone. The prosecution said she had complete control over her emotions, because she had to complete her own plan. And then the prosecution doesn't have to prove motive, but they get into the why. And Sprague said, according to Dr. Resnick, I don't think she should have brought up Dr. Resnick's name. That means she's relying on this renowned expert. I think that was a little bit of a mistake. But she says, Resnick say most women do this out of abuse. She was depressed. She was exhausted. She was done. She was damaged. But those kids were keeping her. They were her protective factor. She used those words. They were her protective factor. It was a choice. She could have unalived herself and left her kids alive. It was a horrible choice. So this the ending that she's I'd say Sprague is putting a little bit more emotion into the ending, which was good. Okay, so she's calm, and then she's letting her emotions come out here, her emotions and her wanting justice for these children. So I thought that was good. So, sometimes if you're really emotional from the very beginning, it loses some of its impact. So prosecution says she could have Kate herself and let her kids live. It was a horrible choice. It's the choice she made, and she knew it was wrong because she sent Patrick out in order for herself to do it. She created this situation. When she woke up in the hospital, she knew what she'd done was wrong because she was horrified. She asked for a lawyer right away on the 26th before surgery. She tried to emphasize that. And she was using Prosecutor Sprague says she used the voice as an excuse. She immediately obeyed the voice. She uses Dr. Resnick, and they talked about Yates, but Andrea Yates was able to resist the voice. But here, if there was a voice, the prosecution is saying Lindsay Clancy never even tried to resist it, so that doesn't make sense. She should have tried tactics to avoid the voice, only heard the voice one time, and that's a red flag in the Sprague's mind that she is making it up. So Sprague is saying there's a lot of red flags here, especially about the voice. The voice was inconsistent. We had 3 different versions of the voice. The voice is vague in its command. It didn't say how to do it. So as a result, Lindsay had to choose how to perform the acts. It didn't say what to use. So she had to figure it out. Oh, I guess, exercise plans. If you're in a moment of delusion, right, and you're listening to this voice, are you that rational to choose your weapons? Each different time. So she basically had to do this 3 different times, 3 different ways. As a result, the prosecution is saying that's rational deliberation. Rational deliberation in that Lindsay wanted to K herself, but also there was a natural instinct to live. And I remember one of the doctors talking about that. What was the natural instinct to live? So the prosecution is suggesting that, that's why it was so hard for her to do it to herself, because of her natural instinct. And then there's a line here where the prosecution said, we never suggested that Dr. Zeisel told her to make up the voice. That was entirely from the defense. So she had to get that shot in. She wraps it up by saying that they have proven beyond a reasonable doubt deliberate premeditation, the way she K'd the kids, the way they died. Specifically, Dawson was first. That's ordered thinking. She knew he was a handful. He might struggle. So as a result, you separate him first and then unalive him first. And then she says, with emotion, she wrapped that band around his little neck. So sad, but that's a visual for the jurors, and they'll be looking at those autopsy photos. That she caused him pain. The blood vessels burst in his eyes. Even if he felt that pain for up to 30 seconds or even 1 second, she continued to make sure they were unalived. So she's saying that this is behavior that is just an indifference. Like, she showed an indifference to human life, leaving them there on the floor, completely indifferent, being done. They must have been so scared and shocked that this was being done by their own mom. And as a result, Sprague ties it in with what the judge's instructions were, that this is extreme atrocity and cruelty. The way they were unalived one by one, their rights and their dreams and their future were taken away from them. She unalived them and left them there on the floor, discarded on the basement floor. And then she asked the jury to come back with a finding of guilty to a moral certainty. So that's my recap. So did they have the press conference? I'm not sure if they had the press conference, if you guys were watching, but I was kind of following my notes and giving you an idea of what I thought about the opening statements. No conference yet. Okay, thank you. Phew, quite emotional. Quite emotional. Well, anyway, I've been doing a lot of talking. I'd like to hear from both sides now. What, not just one side, because I know a lot of you in here are in favor of the prosecution, and I'm trying to be neutral. I'm trying to show you the highlights of both sides. So don't be afraid to speak out. We're the no judgment zone here on the Margaret McLean Show. So please don't feel free to speak out. And I'm going to look at some of the later comments if I can get them up here. So no conference yet. And oops, Amber's texting me. Let's see what Amber says. Amber's the one that just does it all behind the scenes. So I have to say, thank you for the super chats. This really, really sweet of you guys. I appreciate it. I'm a new channel, so I'm not, I'm not like some of the big ones that have, boom, 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 boom. But I really like doing it, and I appreciate all of your patience. You guys were here with me every morning, and I would get my coffee, and I would look forward to listening every day. And so the law is going to be very interesting. They're going to really have to parse that out. Is this first degree M beyond a reasonable doubt? Did the Commonwealth prove premeditation, extreme atrocity, and cruelty? Did they prove that Lindsay was rational at the time the acts were committed? They have the burden of proof to prove that she was sane beyond a reasonable doubt. They can also consider the lesser included. So that's going to take some time as well. Was this manslaughter? Was this involuntary manslaughter? Manslaughter is, well, first degree M, give life without parole. She's in prison for the rest of her life. Manslaughter, though, she would be in for up to 20 years. She'd come up for parole. Not guilty by reason of insanity, but really here it's not criminally responsible. That's what they call it here in Massachusetts. I thought it was very interesting, and you probably noticed this as well. So in the judge's instructions, the judge instructed the jury that if they find her not guilty by reason of insanity, she goes to a mental institution like Tewksbury. So the jury is aware of that, and they will likely take that into consideration. They may think, okay, this woman who, by all accounts, was a loving mother, if they can't decide, right? If they can't decide on which expert to believe, obviously the tie goes to the runner, the tie goes to the defense, but they may ultimately decide this on, well, she belongs in a mental institution instead of prison. That's, hey, by the way, thank you for this. I have so beyond appreciated your commentary and information. I appreciate that. It is going to be, oh, don't worry. It's going to be quiet, not hearing your voice the rest of the day. Hey, I'd like to, I will just be honest. I'm always honest. But last year, when I tried to live stream, I would call my son and say, hey, can you go in, do me a huge favor so I'd at least have one person in and he would like it? So that's what I used to have to do. And now I'm lucky that I have people actually in here and listening. So I'm thrilled. But I do want to, if you do like my analysis, I'm going to try to get better and better. I know I'm not perfect. I have a lot to learn still about doing this, but I appreciate that you guys are here and listening and giving me a chance, because you'd laugh, and I can admit it now, but oh my gosh. And I also did lunchtime law with Margaret McLean. And sometimes I didn't really have anybody in there, but I still would try to do it live because people didn't really know about the show. But that's what happens, I think, when you go do a trial every day, you really get to know everybody who's watching it with you. But I'd like to continue. I really like this group. So, let's figure out what we're going to watch next and what time of day. I'll do it daily, of course. I was doing my lunchtime law at noon, if that works for everybody, but I can also switch the times. I don't know. I don't care. I can do that. But gee, I'm surprised that look at the old picture. It's so sad. And that's what the jury is doing. They're looking at those pictures. I don't know if that one's in there, but that they'll look at pictures like that. They'll look at those three beautiful children. My God, that's why they're going to take so long, in my opinion. Yeah. Okay. Shanti Peace, thank you. Honestly, I felt the defense was very persuasive to show us who Lindsay Clancy is, a mother and a professional. Yeah. I thought the defense did an excellent job. I thought both sides did a good job in their own way. So, this is the most, I'd say it's one of the most riveting trials I've ever watched. It's certainly the most emotional, but it's such a gray area trial. So it's just amazing. Oh, you know what I do have to do? I have to, I have to send. So if you guys, I don't know where anybody stands, so I will be on it unless I get bumped by President Trump or something, which happened before. I will be on the Will Kane show at 4. So, and of course they're saying we want to hear from. They like to know what I'm going to say, a gist of what I'm going to say. So I do have to send them that text. But the Luigi trial. So Chad Wilson asked, when is the Luigi trial? The bummer about that is it's not on television, so we can't watch it every day. And that one might be that New York, those charges might be dismissed anyway. But he's pled out in federal court to those stalking charges. But nevertheless, so when we have Sandra Birchmore is coming up. That's a big case in Massachusetts. It's in federal court. So, I mean, what I can do is do a nightly on what went on in court. So I can do something like that and we can talk about it that way. But there's nothing like really following these cases day in and day out and talking about witnesses. And I mean, it's really interesting. I really enjoy doing it. So I've got to send them their text quickly. Gosh, I'm doing it quickly. It might not be good enough, so maybe I'll be bumped. All right, so I'm sending them this quickly. How long do you guys think? Oh yeah, we did the poll. I think this jury will be out for 3 to 6 days. So I don't know, because it's definitely, I would be shocked. The only way where, in my opinion, the only reason for this, if they do come back early, it's because Reddington presented enough reasonable doubt. So I don't know. Oh, the press is set up for the verdict watch. All right. Amber, in my personal opinion, is not guilty by reason of insanity, but acknowledge those 3 babies are the only truly innocent victims in all of this mess. But there are more than 3 victims in the big picture. Oh, yeah, I think so. And in the big picture, I hope that it does something for women's mental health. And postpartum depression, postpartum psychosis. So that the world, I mean, and we have people in here from all over the world, right? Yeah, no weekend. So, Michelle, they will not be, so Massachusetts is usually stops them around 5 and lets them go home. Saying there's no weekends here. So we're different in that respect. So Lisa, so you're going to tell me that the voice told her to K the children so horrifically and then go upstairs to cause her death so quick with no suffering, only her. Yeah, I mean, that's what the process, I hear you. That's what they're going to be debating. Yeah. And you know what's interesting? I've noticed that when like in this chat, and then when I've been on other shows, I've looked at their chat, it seems that the most vocal are those people that really want justice for the children and believe in the Commonwealth's case. But some of the people that are clearly voting for the defense don't seem to me as vocal. But I think that, again, we still seem, if you look at the polls, there seems to be quite a divide. So of the 12, I wouldn't be surprised if we had some people in that jury who are just so they really, really want justice for those children, and they're looking for a guilty, and they may not budge. So we'll see. And of course, then we could have a hung jury. Yeah, you're right. Massachusetts is different in a lot of respects. It is. So I've heard, and I don't know if this is true, but so my experience when I tried cases, we always ended like at least by 4 or 4:30. We never took it past 5. And I heard it's because, the court staff wants to go home. So that's the way we do it here. And that's just what I heard. But I didn't mind stopping, so I was also a juror in a federal trial here in Massachusetts. It was the same thing. We never went beyond 4 o'clock. No way. Which I think it's good because I think people need to be able to go home and unwind, have dinner by themselves with their families, and just like kind of like I have to. So last night, so after today, and I'll be on. Yeah, I forgot. I didn't forget. But tonight I also will be on Canton or Commonwealth Confidential if you're in the Boston area. So check that out. So, but after I come home from that, drive home, rationally driving, I'll just like to sit outside for a minute and just listen to the crickets and all that, because this case is emotionally taxing for sure. God. Yeah, Michelle, you are really right here. I'm going to put you up. I wish the prosecution put up pictures of the kids during closings. Yeah. Actually, the one who held up the pictures of the kids and the family, that was Reddington. Interesting. So no other chat. I know, Lori, you're right. I haven't seen any other chat strongly in favor of not guilty by reason of insanity either. But when the content creators put the polls up, the polls are divided. I forget what our last poll was, but you're absolutely right. And that's interesting. I find that very interesting. So, yeah, federal trials are not on TV. So what is the next case that will be on TV? And of course, again, when Birchmore comes up, and I forget when that is, it's coming up soon, I will talk about it. I'll have to gather what you have to do, I think, as a content creator is go to court if you can get in, or use a reporter. And I do have some reporters who I really trust to, really talk about what went on in court, and then take that and provide legal analysis based on that. It's much easier to sit here and watch it, Let's see what we have here. There's so much information and lack of information for this case that it makes it so hard to process or go one way or another. So if jurors believe that, then that's defense, not guilty by reason of criminal responsibility. Question. What is the reason defendants don't have? Oh, okay. This is a great question. Why is it that defendants don't have to testify? Because they have a right, a constitutional right to the right to remain silent. Fifth Amendment. If really looking for justice feels like we would hear from them, do you know the reason for that law? That goes way back. That goes way back to the founding fathers and the Constitution. I taught constitutional law, and I get it. I get why. Because, can you imagine if, when you're arrested, let's say you're innocent. Okay. Let's just say you happen to be arrested. You're in the wrong place at the wrong time. And then they took you into a room and they are allowed to interrogate you and you had to speak. That doesn't seem fair. Like, it would be scary. And I think that's a fundamental right, the right to remain silent, all the way from, when the police arrest you or prior to arrest. If you invoke that right, it's a fundamental right. The second you say, I don't want to say anymore, or I want an attorney, you have that right, and it's in our Constitution. Otherwise, I think it would be more of a police state, really. But they can choose. She could choose to testify if she wanted to. Who would want to choose to get up on the stand and then undergo a tough cross-examination by an attorney? Attorneys are really skilled at cross-examination. So even if somebody's innocent, can you imagine having to face a brutal cross-examination? I think that would be tough. So, but that's a great question. I appreciate that. Yes. So somebody, oh gosh, yes. Oh, guess what? I have a judge that can join us. Okay, let's see. So maybe he can join. Let me see if, oh, this would be awesome. Hold on. Sorry if I'm like, I want to hear from Judge Lou. Okay. I'm glad I looked at my phone. I will send, all right, I've got to email him the link. So bear with me now. I'm going to ask him. Oh, there's Amber. Amber, I'm live. I can't answer the phone. Okay, yes. I have to ask him about it. Do you have an email? Do you have an email? And then I can email him the link. Amber said she didn't mean to call. All right, so let's see. And I really appreciate all you guys. I appreciate all the support. So I am going to see what so it'd be really interesting. So Judge Lou has been, Judge Jack Lou. Oh, here he is again. Hold on. Oh, there it is. Okay, so I have his email. And if you can give me a moment and I will invite him in. I can do this. All right, invite guest. I'll copy the link. Link copied. I'm so excited that a judge wants to join us. Isn't that cool? All right, let's see. Hold on. Copy the link. Now I got to go to my email. And I got to put his email in, so bear with me. Oh, good. He emailed me. All right, so now I've got to copy the link. Okay, reply. All right, bear with me. I'm a grandmother. All right, I just copied the link. All right, this will be great. All right, so I just gave him the link. All right. Let's hope he can get in okay. That'll be great. So I'm kind of waiting on him. That's so cool. I'm going to just tell him again, just sent the link. Judy, I'm so behind, still on Reddington. So far, not too impressed. I'm impressed he's doing it out of memory, though. Yeah. So, Judy, you must have gone back to see it. It was, I thought it was very impassioned. It was a different style from what the prosecution presented, but they were both good, in my opinion. I mean, both very good. And so, let's see. I'm just waiting to see if when Jack comes on. So I'm excited. That's so cool. I just want to see what he thinks. And he's probably trying to connect. So I use a streaming service called StreamYard. And it's what everybody else uses as well, but it takes a little bit of time to figure it all out. I don't know if the judge is in the chat. He must have been watching. He's going to come on live with me. And I'm trying to see. So basically, I can look down. This is how it works. And I can see when he enters. I might see if Amber can help him. But I can see when he enters. Okay, so now I'm going to send Amber his email. All right, I'm going to send this to Amber. Because sometimes Amber can help behind the scenes. So we'll see what happens. Whew, what a day. What a day it has been. I can't believe it. Yeah. And I think you're saying that, yes, I like her. The prosecution and the jurors need to think of the children. Yeah, they do. They will. Oh, let's see. Oh, there's Judge. Here we go. Hello. Hi, Jack. Everybody, we're live. And Jack, I appreciate you being here with us. This
I
is
am getting
Judge
feedback.
Lou.
Can you hear me?
I can hear you. Can you hear me?
Yes.
Awesome. It worked. Well, welcome to the channel. So I can hear that I'm echoing on your end. Do you have headphones or anything, or it's not bothering me that much?
Give me one moment to adjust my audio.
Okay. So this will be great. So Judge Lou was a member of the bench in Massachusetts for many years. He's retired, and I should probably get my headphones too. Of course, God knows where I put those. Let me go see if I can find them quickly. Oh, here they are. They're right in my desk. All right. I've got my headphones. Sometimes that helps because it's all about the echo. So, but I'm excited to have Judge Lou. All right. So now, hopefully that'll be a little bit better. I'm sure he's looking for headphones. I can never find my phone. I can never find my headphones. So, so I really appreciate you guys. Oh, there. Hi, Judge.
How you doing?
I'm good. Can you guys can everybody hear him?
I'm still
Can you
getting
hear
an
me
echo. Are
okay?
you getting an echo?
No. I'm hearing you through my headphones.
All right. Well, I am getting an echo, but I think I can understand everything you say. Just give me a little bit of patience as I process everything you say twice, including hearing myself, which is the worst thing of all.
Maybe your headphones aren't connected. Are they connected?
Well, I will play with it.
Okay. So did you
They're
watch the
connected.
close?
Go
Yep.
ahead. Sorry.
Did you watch the closing arguments?
Only parts of them.
Okay. I'm dying to know, what are your thoughts on a case like this? You were on the bench for many, many years.
Yeah. So
And
I
have
don't
you ever
have any
seen a case
special
like this?
insights. This case will be obviously extraordinary for the way it's shown a light on postpartum mental illness, and to a lesser degree, mental illness defenses as well. Yeah, I'm afraid I'm getting a lot of echo. Let me
Okay.
go into. Let me turn everything off and see if I can address that. I'll come back in
Okay,
a
that's
minute.
fine. We have time. I'll keep talking. Maybe Amber can call you. Amber works. She's part of the show and works behind the scenes. So Amber is saying to restart maybe restart
All
your.
right, I'm going to restart everything.
Okay, that's fine. We have plenty to talk about. I appreciate you being here. Okay. So there we go. Yeah, sometimes what happens when you live stream or when you bring a guest on, and so that, if I would have, we would have tested prior to, but he was listening, and I think it's great that he's willing to join us. But lots of time, you can get an echo if your headphones aren't properly working. And that's a pain to be able. I would not want to hear myself over and over and over. That would be awful. Any questions? And thank you so much for being here. And I really appreciate you guys so much. And I appreciate all the support that we're getting. I mean, the channel is growing. So I love the fact that you're helping me grow. You're here on the ground floor. So, question. So how will it work? Is the sentence connected to the verdict, or does she come back for the sentencing? Okay, so if there is a finding of guilty, that depends on the judge. So sometimes the judge the sentencing is, if it's a guilty, then it's mandatory in Massachusetts. You get life without parole. Okay, that's it. But given that, sometimes they do come back for the sentencing because you can have witness impact statements and all of that during sentencing. But in this case, or it can just be announced right from the bench. And many times it's announced right from the bench simply because it's mandatory. But all right, that's M. But let's say it's manslaughter. It's very possible that in that case, she may have to come back for sentencing. She's not going to get out. She'd still be at Tewksbury Hospital. So, but, I think that in that case, the judge would most likely make sentencing on another date because he'd have to think, what does she deserve for this case? She can get up to 20 years. So, what prison does she go to? She would still have to have accommodations. And it's not like she's going to flee, right? She's in a wheelchair and she's still in a locked facility at Tewksbury. So yeah, I think to answer your question, they might have to come back to sentencing, but again, it's all up to the judge. Good question. Yeah, the verdict comes first. You are absolutely right. We have to have a verdict first, and that'll be a few days. So we'll have to parse this down and really talk about it over the next several days, and I'll get some experts on so we can really have some good discussions. So that'll be wonderful. And any thoughts on Reddington's closing arguments. What are your thoughts? What are some of the best cases I've won? So one, no, I'm just kidding. Well, gee, I won a lot of cases back when I was a prosecutor. I mean, there were so many, believe it or not, there were so many of them back in the, I mean, so many, anything from juvenile gang activity to, big drug cases. So I worked up in Lawrence. So that was a very busy area. So all sorts of cases like that. But then I ultimately did leave and I tried cases for the civil side. I did civil defense work. And some of those cases were pretty significant Jack, can you hear me?
I can, and so far, no echo. That's a beautiful.
Excellent. So now let's talk about the case. So we just
I'm
heard.
protein maxing as I talk to you.
What? Oh,
I'm protein maxing as I talk to you.
That's good. I have not had this. I've had like this much water the entire day, and I've been talking the entire day. But this case is so riveting, and I thought the closing arguments were just so good for both sides that I haven't really gotten up out of my seat, believe it or not. So I've had nothing. Well, so what are your thoughts? I'd like to know, you mentioned, yes, I agree, it will bring mental illness and postpartum depression and postpartum anxiety to the forefront so that hopefully the nation can have a serious discussion about it. What are your thoughts? You must know Kevin Reddington. What are your thoughts on Kevin Reddington as an attorney?
He's the best lawyer in town, among a town with thousands of great lawyers. He's a wonderful lawyer.
Yep. Did he try cases in front of you?
I don't think so. I think he appeared in front of me, but I don't remember him trying an actual case in front of me, meaning conducting a bench or jury trial. But on miscellaneous things, he would have appeared in front of me. Regionally, he would have been to the south of me. I hope my audio level is okay.
It's a little, if you could adjust it a little higher that I can understand you.
Let me see if I can.
And if any of you have questions for retired Judge Jack Lew, please put some questions in because I'm sure he's happy to answer them.
Yes, I'm happy to answer any questions. I think for now, rather than changing microphones, I'm just going to try to drive the microphone a little stronger.
Okay.
Or
excellent.
Well, let's. Does that sound any better?
Yeah. Yes, it does. It does.
That's better? So, okay, we'll go with that. Yes. It's a lower tech solution. He's a wonderful lawyer. I don't think he ever tried any cases in front of me. I believe he graduated from a local law school around 1977. So wow. I could be wrong about that, but he certainly has the experience. He's a great lawyer and a great person.
Yeah, that's what I've heard. And if you watched any of his closing argument, he was very impassioned. So what do you think about to me, it seemed like he really believed in his client, Lindsay Clancy, and he truly believed in his case. The passion really came out. Do you think a lawyer can overdo it sometimes?
The real honest answer, frank answer from me is that a lawyer cannot overdo it. There is a minority point of view, and forgive me, I haven't been watching your show continuously. I've tried to drop in each day, but I haven't been able to watch, and I hope I'm not blatantly contradicting you. But the school of thought that says a lawyer can show too much emotion is wrong. I mean, theoretically, is it possible? Sure, it is. Sure, it's not likely to happen though. And if anything. Law students and young lawyers should be taught the opposite, that they need more emotion, raw emotion, blood and guts, everything. That's how you win cases.
Yep, and that's exactly what he did. He was blood and guts and raw emotion. And I think it came across that he's very passionate about his case and his client. And here's a question from Chad Wilson. There has been a lot said about the judge showing favoritism to Reddington. Do you agree with that?
I've only watched little pieces.
Okay.
I hope my audio is okay. I've only watched little pieces.
I can hear you.
But a lot of times what you will see is that it appears that the more experienced lawyer is favored by the judge when what is really going on is that the more experienced lawyer knows what to do better than the less experienced lawyers. The less experienced lawyers, of course, are the prosecutors here. They're still very experienced, but Mr. Reddington's experience is approximately double their experience. So, and the nature of his experience is extraordinary as well. So I don't know what happened, and I'm afraid I most respectfully, seriously doubt that this distinguished judge was favoring one side or the other. But if it's entertaining, that's okay. But I'm not going to end up agreeing with that. And sometimes just the experienced lawyer knows how to act better, and it so encounters less resistance. Sometimes the better lawyer knows how to act better and encounters less resistance. And so casual observers say, oh, there's favoritism. Oh, no. It turns out the more experienced lawyer knows how to do it better and just sort of sails through, sort of.
Mm-hmm. Yeah, I think what they were talking about is there were times when the prosecution had one of their experts on, one of the rebuttal witnesses, and I think the judge, Judge Sullivan, I agree with you, is an amazing judge. I think he handled himself very well. I like the judge very much. But there were some times when he chastised some of the Commonwealth expert witnesses for not, wait for the question. He seemed to get quite frustrated with some of the witnesses. But I imagine it's a taxing on a judge, right, to go through a trial like this. Can you describe maybe what your experience was for a long trial like this?
Well, I'll comment on what you just said. I didn't see what you're talking about particularly, but I would say that these judges, these are wonderful, wonderful judges. They're too nice to the witnesses. They should be tougher. So he should be chastising the witnesses, especially paid witnesses. They're getting paid a high rate of money. They need to behave and do what's expected of them. Usually they know what is expected of them. So I guess I'll theorize that if Judge Sullivan chastised X amount, he should have really have chastised 3 times amount. I'll say this, Judge Sullivan was too nice. And that's just a theory because I haven't seen what you're talking about.
Yeah. No, I like Judge Sullivan as well, but I know that. So it's interesting though, now that trials are on TV, right? They're on everybody's computer. Like we watched it gavel to gavel, and we were able to see. Do you think it makes it harder for a judge to? Obviously, judges have to appear neutral. Do you think it makes it harder knowing that the trial is nationally televised?
I don't think the judge cares about how they appear, he, she, or they. I don't think they care about that. I think they do care about things like influence on the sitting jury and communication with the sitting jury and pressure on the sitting jury and even intimidation of the sitting jury. And then that same whole series of things as to witnesses. That is a fundamental societal problem that we should all be wrestling with now, because this case opens up, puts a little sunlight on the problem even a little cleaner, because Mr. Reddington did not conduct a social media defense, and yet social media went crazy over this case. And my working hypothesis, subject to change and more evidence, is that it influences the verdict no matter what. And that is a new phenomenon mostly. And we need to deal with that, and people should be talking about that.
Yeah, no, I agree with you.
As you know.
Yeah, no, I agree with you. And one thing in this case early on, again, I covered this gavel to gavel with the same chat, the same group of people. And you
have my sympathy.
Yeah. Well, in my group, I have a great group, though. I really enjoy some of the factors here. I mean, some people we're divided. Some people are in favor of the defense. Some are pro-prosecution. But since the beginning, people would ask me, what do you think? Do you think Patrick did it? So they started asking me about these conspiracy theories. Now, if you followed the trial, there is no evidence whatsoever that any of these conspiracy theories that people have drummed up out there are real. And Patrick Clancy was, if anybody listened to that 911 call, Patrick Clancy was just horrified at what he found. So there's no evidence supporting any of those conspiracy theories. And I actually wrote a Substack article about that, debunking each and every one of them. But I think in this case, it's more clear. But in other cases, I think people can run with conspiracy theories. Like, if there's a question about a police investigation or a corrupt police officer, those conspiracy theories usually go rampant. And that's not good. So we have to figure out a way to address that. Do we start sequestering juries again? What do you think about that?
I think it's worth serious consideration. I think it's also, there are other measures, but so far I don't have a magic bullet, but I am actively thinking about it. I think that jurors should be required, the things that judges might consider are having jurors sign a daily order about social media and outside communications, perhaps doing a voir dire of every jury every day or every other day or randomly about whether they have been consuming social media or other communications or protests or any of these things. So it's a difficult problem. I'm still trying to unravel it myself. These conspiracy theories are very wacky. And it's, I'm only appearing on this show for you, Margaret.
I appreciate that.
I am not a fan of YouTube. I'm sure your audience is wonderful, but I'm not a fan of this whole enterprise. I guess I will leave it at that because I don't want to divert you into controversial things, but I'm not a fan of the genre. Yeah,
the one thing I will say is I am trying to create a channel that is I'm just trying to be an open-minded channel, right? But if it gets crazy with the conspiracy, I'm allowed to, say, all right, that's enough, right? But so I think what's important is I like to do what I'm doing because I like to educate the jury. I like to educate viewers out there about the law, about why why does the prosecution go first in some states and last in other states, and little things like that. And, what the strengths of various witnesses, why lawyers are doing what they're doing. I enjoy really talking about the law. And I think you do too. You and I have been on shows together where we really like to talk about the law, the evidence, and the facts, and keep it to that instead of rambling on these crazy rants or theories. So I appreciate you being on my show for that very reason. And you've been on it before. I've grown a little bit since then.
On my imperfect understanding, you seem to be the most prominent commentator on this Massachusetts case, and that pleases me.
Thank
but
you
I'm no
so
expert.
much.
I'm no expert, so I'm enjoying that. And
thank you.
That's a
I
great
appreciate
question
it.
at the bottom there.
Okay, I didn't see it. I've got my readers at follow up because of follow up. Bones are in the inside because of mistrial request during the trial. Oh, if she is found guilty, do you think she will pretty much get a retrial based off the religious comments? Yeah, that's a great. Thank you so much for bringing that. So that's a really good question. So let's talk about those religious comments. You've heard about them, right, Judge?
I have.
Okay. So the prosecutor, the first time it came out, we had Susan Clancy on the stand. She's the mother-in-law of Lindsay. And the prosecutor asked, "Are you a Catholic?" "Yes." Do you realize M is a mortal sin? And all of a sudden, everybody went to sidebar, objection, sidebar. The second time it came up, the expert was testifying about his interview with Lindsay Clancy. And he was talking, so he was trying to see what's going on inside her mind. And it was a prosecution rebuttal expert. So he's testifying about, well, we talked about the acts and the voice that she heard, and then he wanted to get into the morality of, is her baseline? What's her moral baseline? So that's why he got into that, according to the prosecution. He got into that, and he said, he got into the mortal sin. Or are you Catholic? And do you think, is it your, forgot how he worded it, but moral belief that it's a mortal sin? I can't say that MURDER here because I'll get unmonetized. So is M a sin? So what do you think about that? So let's parse that out. What about the first time, Judge? Do you think the prosecutor, it was awful that she brought it up? Sanctionable? What would you have done?
I think they've done a good job, the prosecutors. I applaud the choice of female lawyers for a high-profile criminal trial in Massachusetts, which is not done, which I condemn. So I harshly criticize the DA's position in bringing a first-degree case here, but I applaud the appointment of 2 female lawyers to try the case. That, however, was a serious error, and somebody wasn't thinking straight when they decided to get into that. That was a serious error. Incident number 1.
Mm-hmm. So incident number 1, how would you have handled it as a judge? What if Attorney Reddington had asked for a mistrial during incident number 1 because he didn't at that point? Would you have granted it?
I absolutely would not.
The first time he didn't ask. Now, if he had asked, you would not have granted a mistrial?
I would not.
What would you do?
I think the judge handled it perfectly. I don't. It's not at the right in my memory exactly what he said, but he interrupted on his own, which is good. Mm-hmm. Which sends a message implicitly to the jury, and he said words to the effect of, "That's improper. Don't consider those words. It's as if those words were never spoken," which is an instruction to the jury, and is perfect. I think he handled it perfectly. I think he probably did it better than I would have. I would have tried to do what he did.
Yes. And then the second time
he
around,
interrupted rather than waiting for an objection. The jury's not dumb. The jury gets that. They see that. Right.
Do you think, so the second time around, when Reddington asked for a mistrial, he didn't grant it, but he gave he actually sent the jury out of the room, then they came back in, and he gave a very strict curative instruction. And I'm sure you would have done the same thing.
Yes, I would like to think I would have done the same thing and interrupted and told the jury forcefully that that's improper, kind of crazy, and not something you can consider. Act as if those words were never spoken. I think the judge handled it perfectly.
Okay. Now, let's say Lindsay Clancy is found guilty and there's an appeal. Do you think this is an issue that an appellate lawyer would raise on appeal?
Definitely. It would be one of the main issues on a many-issue brief, because there are many issues in a case like this.
Okay. What stands out to you as some of the other issues? Or what would they
I'm not sure I can think of another issue in this case. You know what will be an issue inevitably is, though, the interplay and interaction of mental illness, mental health, the elements of murder, and the voluntary or involuntary use of medications, and what is voluntary and what is involuntary, and how does it matter if they're prescribed by a medical professional. So all of those areas are somewhat developed in Massachusetts, but not particularly deeply. So if she loses, this case will develop the case law on all of that complicated area. I haven't seen the instructions the judge has given on that subject, but you can bet it'll be amplified and clarified if there's a conviction on appeal. And no matter what, if there's a conviction, I imagine that the defense will not only talk about the religious references, but also claim errors in the handling of this whole intoxication, medication, mental health, mental illness defense.
Yes, he did. So Judge Sullivan did instruct on murder, M in the first degree. He instructed on manslaughter. And also he gave the instruction, so the jury knows that if she is found not guilty by reason of insanity, or what we call criminal responsibility, she was not criminally responsible. He told the jurors that she won't be out in the street, but she will be in a secure mental facility like she is now, and and the courts will be involved, and it will ultimately come up for a yearly review. But he made it clear that the courts are involved in the final decision of whether she gets out or not. So I think, what do you think about the jurors knowing about that? I think that may ultimately sway them if they can't decide. Of course, if they can't decide, it should go to the defense. But ultimately, they will have a discussion, in my opinion, that will listen. Does this woman belong in a prison, or does she belong in a secured facility where she can still get the treatment? I mean, she is in a wheelchair, so they may have some sympathy there and come back with a not guilty by reason of insanity as a result. What do you think?
Well, that's a standard instruction in Massachusetts, not guilty by reason of insanity cases. But it's a remarkably strong defense case on the issue of criminal responsibility / insanity, whatever you want to call it, the mental health defense. It's really very strong for the defense. Nevertheless, the numbers don't lie as far as I know. Conviction would seem more likely than acquittal, just based on what happens in other cases like this, and considering how horrific the acts are. If the acts were less horrific, it would increase her chances of winning. But this is a tough case. It could happen though.
Yeah, I think it is the toughest case I've ever followed. And there's so many gray areas here. I know that what you're talking about is statistically, it's very hard to win on a not guilty by reason of insanity defense. It very, very rarely happens. But of all the cases I've seen, I've heard of, or I've read about, it seems like there is a lot of evidence here that she was suffering prior to. She has a history with mental illness after giving birth. A few months after giving birth to her last baby, she was trying to get help. So Reddington is also, it's an indictment on the medical community. Are we doing enough? This woman was trying, she had hope, yet here she was placed on a concoction of all these different medications. So he's also blaming the medical field or the providers for not doing enough or not seeing the red flags. In other words, more should have been done for this woman. So maybe on that basis, they will come back and say, this is one of those exceptions where she does belong in a mental institution, not in a hospital. But yeah, you've got those 3 beautiful children, and they're going to be listening to that 911 call. They'll be looking at those autopsy photos. I mean, it's just horrendous. It's awful. You're right.
It could happen. It could be an acquittal or not guilty by reason of insanity. It's a possibility.
Yeah, I think it's a possibility, or a hung jury. Now, knowing the district attorney, Tim Cruz, do you think if it is a hung jury, he'll try it again?
You can bet on it.
Yeah, I know. I knew what your answer was going to be. I agree with you. And by the way, that's my county.
But maybe he'll surprise us. Maybe he'll surprise us.
Maybe. Yeah, it's so emotional. And by the way, my viewers know this, but I'm a new grandmother. My daughter just gave birth to twins. Yay!
Congratulations.
Thank you.
That's
So it's been
emotional.
Yeah, it is a wonderful thing, but it's emotional because I think of those babies, right? That I hold, and I think of baby Callen and the mother in me, and it's very tough. And I think these jurors are going to bring in their experience. And that's what they're supposed to do. Are there any new grandmothers on the jury? It's who knows what's going to. Here's some Here's a question.
I will
Sometimes
say this. I
yeah,
will say this, that jurors and members of the public do not appreciate mental illness, so they don't appreciate the enormity of the challenges that people face all the time, and the ubiquity of mental health issues. I'll leave it at that. I hope you're right.
yeah, yeah, yeah. I think so, and I think many of us. So my dad's generation. So my dad was a World War II vet, and that generation didn't talk about mental illness at all. It was taboo, and I don't know if you noticed that either back in the day, but I think cases like this are bringing mental illness to life. I mean, I personally, I've told the chat, I've got a very close family friend who suffers from mental illness, and they do have to try different medications to help somebody with psychosis or through some of these mental, we've got a long ways to go with mental illness and treating it. The treatment plans, it's tough to figure it out. It's a case by case basis, really. So, and then here's a question somebody has. Do judges get training on how to maintain a calm face and not show bias? That's a good question.
These questions cannot be random because they're so good, frankly.
Yeah.
I hope that's not an insult. Judges and court employees get what they call secondary trauma from doing these cases. And this case is a prime example of how the judges and court employees, and actually members of the media, the Globe, Herald, and Mass Live, and all those folks, they're in there getting the brunt of it, and everybody needs to take measures to protect their mental health watching a case like this day in and day out. So judges and court employees have the same thing, only it's worse that they can't show emotion, and you don't have to be a psychologist or psychiatrist to know that can't be healthy.
Right.
Do they get training on how to maintain a calm face? Not on how to do it, but they are inculcated with the idea that they must maintain a calm face.
Right, yeah.
And it's not particularly healthy.
Yeah, it's tough. I mean, you have to show that you're not biased for one side, and it's got to be frustrating after a while and exhausting, and you have to make all sorts of decisions and rulings on motions and listen for objections. I don't know how you did it. It's tough to be a judge, So thank you for your service, being a judge for so many years.
I don't need any thanks, that's for sure.
I disagree with that. I think it's taxing to get up there and listen to these cases, human stories, day in and day out. So I think you guys have it tough. I really do. So anything else that you guys would like to ask Judge Liu while I have him here? Amber, do you have any questions? She's my main person. So I don't want to keep you too long here, and I've got to wrap my thing up. I'm actually going to be on Fox at 4, so you can turn on the Fox National. So I'm excited about that.
That's good. I saw you on Fox, on some version of Fox.
Yep.
And I was happy to see that. And
good.
And I'm supposed to talk to somebody. Fox is like this multi-armed hydra. Yes. And I'm supposed to be on something at 4, and if it's on the same show as you, I'll be sure to ask you a provocative, unexpected question.
Oh, don't.
Just to make it more difficult.
Don't do that. That's so funny. I wonder if we're on the same. We could be. You never know. We could be on the same show. But yeah, it's hard. It's hard when we have. Luckily here we can have a conversation, but sometimes it's hard to keep it to a soundbite. And we were on NBC together too, and it's tough. But I'm sure you answer way better than I do. I have so much to say that it's hard to whittle it down into a soundbite. So, but I really appreciate.
I might be
here's a question.
Some people want.
Here's a good question. I got to show it. Amber, is therapy offered to judges or attorneys or court officials that have to endure these traumatic and brutal cases? And she says, I hope so. Does the state offer anything?
But the judges and court employees can get mental health treatment through their health insurance. attorneys, at least in Massachusetts, I believe, they're more or less everybody's required to maintain health insurance. But attorneys without health insurance, I guess, are on their own. And
Yeah.
of course, the whole health insurance thing and mental health treatment is a part of this case that wasn't really dredged up much, but that is a nightmare. And I will say our health insurance system is badly broken. I've got to leave it at that.
Yeah. Oh, yeah. Yep. It certainly is. It is. And one thing they did bring up, so the prosecution brought up health insurance, and she said, well, Lindsay Clancy had it better than most. She had access to all sorts of medical providers. She had insurance. She chose to control, how did she say it? She chose to control her own treatment. Basically, the prosecution saying she didn't follow up with what her doctors were trying to do for her. She went from doctor to doctor and tried different medications. So they put the blame on Lindsay Clancy. But that's the only area where it was really brought up, was by the prosecution in this case. Not by the
Yeah, they're
defense.
trial lawyers trying to do a good job, and they're doing
Yep.
a good job, but that's a pretty wacky view of things. The health insurance
Yeah.
system is badly broken. We'll talk about that on another day. But
Yeah,
it
100%.
is profoundly broken.
We should talk about, well, let's do that. Let's plan to talk about that on another day. But in the meantime, thank you so much. Okay, wait, here's one more question. So it's hard for me. These glasses need to be, do you think Lindsay's crying out of, to be biased for the jury? I thought she was crying when she was seeing the autopsy photographs. I thought that was real. I really did. I mean, the way she was shaking and crying, I do feel that she has remorse. This is just my personal opinion. Did you see that, Judge? What do you think? Did you see her crying?
I think the whole social media world, as scary as it is, misuses the word bias. So she cried out. Will the jury consider it? Yeah, you bet. Absolutely. So what?
Yeah, I imagine they'll sympathize with her, because I felt sorry for her.
I would
at the
imagine
time.
so too. But boy, these juries and the public in general are really tough on insanity defenses. It's part of America's hyper punitive criminal legal system. Our hyper punitive criminal legal system. It's all part of that.
Yeah, that makes sense. And I'm seeing that as well. So I'm seeing, not only on this show, but the other shows that I appeared on, it seems like people are on the side of the Commonwealth here. But then the polls, if we secretly poll, that it seems more divided. But the people who are outspoken seem to be more on the Commonwealth side. It's just something I've noticed. But we shall see what will happen, because to prove a case, to prove sanity beyond a reasonable doubt, I think it's a uphill battle for the prosecution. But I'm thinking
So this is an affliction that only happens to women. And so we've got lots of gender bias.
True.
And we also have, it's also an offshoot of the bias that comes out of the attractive white woman syndrome. Except this is not a missing attractive white woman. This is a criminal defendant, an attractive white woman who's on trial for her life.
Right.
So it's a complicated thing to unravel.
No, it's you're 100% correct on that, in my opinion, because even missing persons cases, and I won't take too long here, but I remember when Anna Walsh, who was beautiful, attractive white woman, went missing, and here in a beautiful town of Cohasset, 2 other people were missing, I think just about the same time period, the same day or week, and they were not, they were not attractive white women from beautiful areas. So I'll leave it at that.
Yeah,
And the press
I'm glad
gave
to
them
see you
nothing.
taking the load in terms of Massachusetts commentary for national providers, so I don't have to talk to them.
Yeah.
So.
Well, thank you, Judge. I really appreciate you coming on the show. You make it very enlightening, and it's wonderful that we heard from you. So thank you so much.
Have a great day. I'll talk to you soon.
Okay, talk to you soon, Judge.
Bye-bye.
All right. Bye-bye. Well, that was enlightening. And my goodness, it is 2:17 already. I can't believe I've been talking for this long. I'm just looking at some of these. It's funny. I haven't even. I don't think so. I didn't drink any water, as you know. I drank a little. I haven't even had to get up for a break. You know what I mean? So it's. I think we've had a very, very great. I appreciate you guys so much. I appreciate the chat, and we keep the note. Put the notifications on, because I will be talking about this case. We'll have to figure out a good time. Maybe, I'll just get on in the morning like I did before. So, but keep the notifications on, because I want to keep this thing going. I really appreciate your support for the channel. And we will obviously I'll keep you guys posted on every development, every question, and I'll try to put together some good shows with some interesting guests on as well. So that'll be good. I really appreciate it. That's funny. If I had, this is a good one. If I had a YouTube channel, I'd not come within a country mile of this case. I get it. It's emotional. I mean, I'm exhausted by covering it. But for me, it's such a gray area, and it's an important case in so many different respects. No matter which side you're on, it's an important case. That's interesting. Pink Door, I find it offensive how fast people are commenting on the system. Perhaps more detail on your below. So the system itself, I think we're doing the best the justice system does need improvement. I think jurors do their best. The healthcare system, I think it's pretty good here in Massachusetts. I've been able to get good doctors. There are good hospitals, but I don't know if that's the case for the rest of the country. So it's hard to say. I mean, I'm not an expert in that field. I'm just kind of going by what I've been able to, and I've also seen some, my family friend has, I've seen good and bad, but some of the facilities are excellent that she's gone to, some not so much. So there is definitely room for improvement here. Are we ever going to know why? I don't know why she did this. It's hard to say. And I missed Amber's. I can go up though. I got to figure out. Let's see, Amber. I missed what you said, but I'm going to go back. Oh no. I'm going to try to go back and see what you said. Sometimes I can't figure out how to go back. Oh, there we go. So this is interesting. I'm going to bring this up. Amber, you asked, why can't the defense be both for Lindsay Clancy and her children? She's saying she did it, the defense. So, I thought Reddington, well, he started out having sympathy for the children and the victims, but he's basically saying that because she was in such a psychotic state, what loving mother would do this to their children? So that's where he was going with it. So I think he does have compassion for Lindsay Clancy and the children. I think he did a good job. I really do. So, all right. In the meantime, I have got to take a break, but I promise you that I will be back discussing this case. So put the notifications on. And if you haven't subscribed, please subscribe, because we've got a lot of good stuff for the future, don't we, Amber? I'm sure you agree with that. And I have such a great team behind me. And I have to say thank you so much to Steve and Amber and Collier. So I have a team of 3 that are just wonderful. And they make this show what it is. I wouldn't have come this far without them. That's for sure. I'd be still asking my son to call in and comment. Seriously, I'm not kidding. All right. Well, anyway, thank you so much for the support, for all of you who have supported the channel. I appreciate it so much, and I will be back shortly. So I'll let you know when I'll be back. Hopefully, don't worry, you'll hear from me every day. Have a great afternoon, and we'll keep watching, see what the jury is doing.